Good morning, everyone. This presentation is going to provide a short overview of the toolbox section that relates to climate change and environmental law. And I'm going to endeavour in this presentation to talk about three key areas, highlighting some of the most relevant cases that we've seen to date, the most common hurdles and challenges, and also the prospects for future litigation in this area. So we've seen that climate change and environmental laws have been used strategically in corporate climate litigation. And in terms of those sorts of laws, they're coming from different places. Some are international laws or principles, some are regional laws, and there's also a lot of domestic laws that are being used in these ways, that whether that's specific climate change laws like a Climate Change Act, or environmental laws that are being used for the purposes of climate cases. A common type of case that we're seeing is one that's using an environmental impact assessment pathway and essentially mounting a challenge to the adequacy of the environmental impact assessment that's being conducted by a company in relation to a particular project. In my own jurisdiction of Australia, we've seen a large number of these cases, particularly around coal mines or coal-fired power projects, where the allegation is that the company hasn't adequately assessed climate change impacts as part of doing that environmental impact assessment. Another example that's discussed in the toolbox is the French case of Friends of Environment versus the Prefect of Bouches-du-Rhône and Total Energy. This is an example where the Administrative Tribunal of Marseille in that case partially invalidated Total's permit for a biorefinery factory, essentially because of the failure to adequately assess the biorefinery's impacts for climate change. A number of these cases also invoke the precautionary principle alongside an environmental impact assessment pathway. And an example here is the Chinese case of China Biodiversity Conservation and Green Development Foundation versus Yalong River Basin Hydropower, where the court used the precautionary principle essentially to put a thumb on the scale in favour of erring on the side of caution when looking at the extent of impacts on the environment. There's also been recent legal developments that really showcase the judicial commitment to enforcing not only local environmental regulations, but also aligning them with global environmental standards and commitments. And a good example here is the Indian case of Hindustan Zinc, where the court upheld a 2012 order mandating companies purchase a certain amount of renewable energy power, a minimum amount of power from renewable energy sources. And in the judgment, they pointed, amongst other things, to renewable energy commitments in things like the country's national action plan on climate change, and that the renewable energy purchase obligation was deemed to be consistent with India's international climate obligations, including those under the Kyoto Protocol. Some of the main hurdles that are being encountered in corporate climate litigation in this area where we're using climate and environmental laws are really not that dissimilar to those that we face more generally in the broader field of climate change litigation. So this is like questions over whether it's really the role of the courts versus the role of governments to be intervening on these climate issues, questions around establishing standing, and the complexities of trying to establish a causal link between a particular activity or a particular corporation and the broader global problem that is climate change. One instance of this that we saw early on in the US, some of the early cases there challenging corporations, whether that was auto manufacturers or oil companies, failing at the very first stage around questions of political doctrine, essentially a barrier to the courts intervening where the question was seen to be one more for policymakers than for courts to decide. There's also more recent iterations of these types of claims in the US that face a significant causation challenge. Just getting before the courts can sometimes also be a hurdle in of itself if there are restrictive standing rules that are applied. This was the fate of the case, the 1997 case of Ontaro Douglas versus Shell in Nigeria, where again the plaintiffs were trying to address the issue of gas flaring, but the court applied standing rules very restrictively, such that they weren't actually able to argue the merits of that claim. More generally, there can be a challenge in applying statutory frameworks, like the UK's Climate Change Act, in corporate litigation, and that's simply because those sorts of pieces of legislation are set up to focus on government accountability for policy and decision making, rather than seeking to provide a specific avenue for corporate accountability. Another barrier that we're seeing emerge is significant discretion granted to decision makers under environmental impact assessment and other environmental laws, which sometimes prevents rigorous enforcement of climate change related obligations on corporate actors. And again, we've seen this in a variety of jurisdictions. There are cases in the toolbox, for example, from Japan and Nigeria that illustrate this issue. In terms of the prospects for future litigation in this area, there are many new laws and legal innovations emerging that could provide an avenue for future claims. There's a lot of excitement, for example, about the EU's proposed corporate sustainability due diligence directive, which could provide a pathway for new claims, or the revised OECD guidelines that were reissued in 2023. These both evidence a greater approach of corporate accountability for the impact that companies' activities have on the environment, on climate, also on human rights. The case law is also generally imposing greater government accountability for not just setting targets, but how they're going to meet those targets, which we often call transition planning. And as some of these cases are being brought, for example, under the Climate Change Act in the UK, there might be potential to transpose the reasoning from those cases to a corporate context to try and hold companies more to account for, for example, how they're going to achieve their net zero targets. Finally, I think there's opportunities to leverage different combinations of laws in this area to enhance corporate accountability. So we're seeing in some jurisdictions like the Philippines, which does have a Climate Change Act, that being used in conjunction with laws around disaster risk reduction to help provide a firmer legal basis for claims. Similarly in Kenya, again, where there's a Climate Change Act, this is being combined with environmental management laws to provide a stronger legal basis for these claims.